the 19th of February 2024, a three-justice panel of the New South Wales Court of Criminal Appeal provided a ruling regarding the law governing drug driving in New South Wales, which lies under Section 111 of the Road Transport Act, 2013. The ruling upheld a 2023 New South Wales District Court appeal decision that saw Judge Mark Buscombe find drug driving to be an absolute liability crime, which means there is no defence of honest and reasonable mistake of fact. Sydney criminal lawyers asked former New South Wales Magistrate David Heilpern what this means, as there's now no excuse for drug driving in New South Wales. "I'm extremely disappointed and surprised," said former Magistrate Heilpern. "This means that drug driving offences are now absolute liability offences. That means it doesn't matter how you came to have the drug detected in your saliva or in your blood or in your hair follicle, depending on however they want to take it, because it's a zero reading that's required. This means that however it came into your system, you are liable. There is no longer an honest and reasonable mistake of fact defense." I have 3 comments on that, said the former magistrate. The first is the implications for this are well beyond drug driving. Clearly, this applies to low-range PCA, and it doesn't matter how the alcohol got into your system. There is no longer a defense of honest and reasonable mistake of fact, which there had been up until this decision, but it extends also into a whole range of other traffic matters that are also absolute liability offences. So, for at least 30 to 40 years, there has been a defense to driving unlicensed, driving unregistered, driving uninsured, that there was an honest and reasonable mistake of fact that it occurred. On this judgment, that defense likely no longer apply to those offenses either. Secondly, this judgment, when I first read it, I thought perhaps, and I hope, this will increase pressure on the government to change the drug driving laws. I say that because this closes one of the only available defenses to this offense, and it means more people will be liable than were prior to this decision. I had people before me, drivers, who didn't know how they had drugs in their system. It may have been through casual contact. It may have been through a drink they shared. It could have been a spiked drink. They just have no idea how the drug got into their system. They will now be liable. There are now 1 million people who use medicinal cannabis in Australia. That is not the number of prescriptions, that is the number of people. In New South Wales, I don't have the exact number, but you would expect it to be somewhere around a third to a half of that totality. That means that they are running even more of a gauntlet than they were before, because they can't rely on the defense of honest and reasonable mistake of fact any longer. The third comment is that the judgment itself is extremely disappointing, and I'm critical of it, in one key regard. One of the factors that was found is that the penalty that is disqualification and fine is minor, to use the words of the judge, Justice Chen. Now, what he says is, whilst I accept that the suspension of a license may bear heavily on a person, the loss or suspension of a license in the overall scheme of things, irksome though it may be regarded as towards the bottom end of the scale of criminal punishment. Now, while recognizing hardship to use words like irksome is, in my view, out of touch with the reality of the gravity that people find themselves in when they lose their license, in particular in rural and regional Australia and NSW, but also for those who rely on their license for work. It is not irksome to lose your job and your house, to lose the ability to travel or assist your children to sports or medical appointments. That is not irksome, that is really serious. And it's not just me who says that. I sent you an email overnight with a full NSW Criminal Court of Appeal decision from 2004 by a preeminent criminal law judge in NSW, Justice Howie, who says, "License disqualification is such a significant matter and can have such a devastating effect upon a person's ability to derive income and to function appropriately within the community that it is a matter which, in my view, must be taken into account by a court when determining what the consequences should be." So, in other words, previous courts have rightly recognized the devastating and serious effect well beyond irksome hardship, and I am really critical of His Honor Justice Chen for not finding that loss of license is significant. What he says is that you can rely on judicial discretion. Well, he may or may not be aware that magistrates have very limited discretion. Indeed, no discretion in some circumstances for this offense. For example, if someone has been convicted of another major offense within the last 5 years, they can't be dealt with by way of Section 10 and keep their license. He also says that you can rely on prosecutorial discretion. Well, my experience in the area of drug driving, and speaking to a lot of my colleagues, is that prosecutorial discretion to withdraw such charges is non-existent or extremely rare. So, I am critical of the judgment because it is out of touch with the seriousness where people lose their license. And had that been taken into account from a more practical and coal-faced perspective, then perhaps the decision would have been different. In the Facebook pages that I am on, and the discussion pages that I participate in, criminal practitioners who readily appear in traffic matters roll their eyes at the thought that someone would describe loss of license as irksome and of not a serious consequence. In my experience, nobody really cares about the fine. All they care about is whether they are going to keep their license, because it is so crucial to so many people. Going to court. Call Sydney Criminal Lawyers on 9261-8881 to arrange a free first conference. Watch our latest video here.